Fox News alert on concerns surrounding a disturbing new report claiming that the Obama administration has launched a counterterrorism plan to gather information on millions of innocent Americans, including people not suspected of any crime. Brand new hour of America Live. Welcome, everyone. I'm Megyn Kelly. The Wall Street Journal published a big exclusive today on a new dragnet that is so controversial there were actually internal battles in the intel community as to whether this thing made good public policy and made any sense. The program reportedly allows the little-known National Counterterrorism Center to copy any government database. Now, this could include things like flight records, federally backed mortgage applications, even the names of people hosting foreign exchange students. It allows the government to go looking into your government records for possible criminal behavior, even if there is no probable cause to believe that you, as an American, have been caught up in anything illegal. And then that information can be given to foreign governments to look at. Joining me now to discuss it, Judge Andrew Napolitano. He's our Fox News senior judicial analyst, and he has written extensively about the legal issues with different counterterrorism programs going back through the Bush administration. Judge, good to see you.
Good to be with you, Megyn.
So they say that there was fierce debate within the Obama administration about this because some were saying, you know, this is crazy. You can't just go be – there's a law that actually was passed in the early 70s after Watergate and so on saying, no, you can't go just like at random looking through people's government files because you want to check them out. And the folks who were on the counterterrorism side won out saying, look, we got to do it. If we have reason to believe that the person might be involved in something, we're going to do it. And that's apparently the new policy.
You know, our friends at the Wall Street Journal have really done the country a great service and great favor by revealing the nature and extent of the debate. But Megyn, if this debate is to happen at all, it should happen on the floor of the Congress, because the Congress enacted, as you indicated, shortly after President Nixon left office, a federal statute to prohibit the government from doing this. So if Homeland Security says we want Megyn Kelly's IRS returns, under the law, the IRS is supposed to say no. If you want them, you have to sue her, and we're going to defend her because we have an obligation to keep that type of information private. Apparently, President Obama is going to issue an executive order and may have done so already.
Well, they say Attorney General Eric Holder already signed this. He already signed the changes into effect. You
know, the law is a strange one. So one might say, well, how can the Attorney General modify a law of the Congress?
Right.
Here's the way the law works. The law says that the custodian of the documents may give them to another governmental agency if the custodian, let's say the IRS or the FAA, if they publish in a document nobody reads in very fine print that these documents are now available for other government agencies to look at. That does not adequately tell the American people that a particular agency is claiming an exemption from the law.
Right, so they can publish some notice in this thing called the Federal Register, which,
right.
You know, when was the last time you read the Federal Register, folks sitting at home? You know, it's like USA Today, Parade, and then, oh, yeah, I forgot to check the Federal Register. Look at this. They're about to spy on my documents. Interagency within the federal government. I mean, it's such a joke to presume that gives real notice to people.
You could fit in a broom closet the people in the United States of America that are even familiar with the existence of the Federal Register, much less have read it.
But that's what makes this legal, because they told us about it.
Correct.
And yet there was an internal debate by some folks saying, okay, legal schmiegel, is this good policy? Should we? The Fourth Amendment prevents unreasonable government searches and seizures on Americans. So a government search is not allowed normally in this country unless a high standard, a high bar, probable cause to believe something, reasonable suspicion to believe something. Here it's, well, do you have some reason to believe? Okay, go.
Well, you know, now we get into this conundrum where something can be legal, that is, it technically complies with the law that Congress wrote, but unconstitutional because it blatantly, on its face, violates the Fourth Amendment and the meaning of the Fourth Amendment. The whole purpose of the Fourth Amendment was not just to prevent the knock on the door in the middle of the night without approval of a judge. It was to prevent fishing expeditions by the government. And when the government can march through private documents of which other parts of the government are necessarily the custodian, like an application for a federal-backed mortgage or an IRS return.
Or your health records at the VA if you are a veteran.
Correct. And now, Megyn, under the Affordable Health Care Act, everybody's health records are available to federal bureaucrats, not just the federal bureaucrats in HHS, Health and Human Services, but all federal bureaucrats after what the president and the attorney general agreed to last week.
Okay, but there is a standard. They say that the National Counterterrorism Center cannot do it. They can obtain almost any database that the government has on you.
Right.
If they reasonably believe that information to contain terrorism information. So they can't just go pull my IRS reports or, you know, some veteran's health records or your health records unless they reasonably believe that that information is going to have terrorism information.
Here's why that reasonably believed standard is nonsense. Because any standard governing the behavior of people in the government should be written by the Congress and not by the bureaucrats who are going to have to apply the standard.
It's too subjective.
Correct. And secondly, unless this information that they obtain, one government agency from another, about you or me or anybody, is used against us in a court of law, we will never know that they have it. So we will never be in a position to challenge it. We will never know what the standard was. We won't even know who exercised that standard. All this is a blank check for the government to run rampant over our privacy rights as it does all the time, without authorization by Congress and in a manner that the public could never imagine.
You know, Judge, President Bush came under fire when he had, you know, they were listening in on these telephone calls that Americans were having if they believed a terrorist was on the other end. And he and the administration got severely criticized, and many defended them at the time by saying, look, first of all, they're saying a suspected terrorist has to be on the other end of the phone. But second of all, we're talking about terrorism. And the country gives the administration more leeway when it comes to protecting this nation against a terrorist attack.
I think you're right. I think that the right to privacy is gradually slipping through our hands because the government has scared a lot of us into believing that somehow by giving up our privacy, by surrendering it to bureaucrats, they will keep us safer. Judge, I don't buy it. I don't think you do either.
I'm not telling you how I feel. So there.
All right. Megan, Merry Christmas to you.
To you too, Judge. Thank you for being here.
Pleasure.